Order. The second stage of the Legal Aid and Coroners Courts Bill. Call the Minister of Justice.
Thank you, Mr Deputy Speaker. I beg to move that the second stage of the Legal Aid and Coroners Courts Bill be agreed. I begin by reminding the House that when I was elected Justice Minister, I said that my goal was to create a better justice system for everyone, for people who are victims of crime, for those involved in seeking redress through the civil law or who need the assistance of the legal system to resolve disputes, for those who are called to give evidence, and for those facing prosecution as defendants. To help inform my thinking about how to achieve that goal, I commissioned a review of access to justice in Northern Ireland, including criminal and civil legal aid. The final report of that review was published in September 2011. It recommended that the Northern Ireland Legal Services Commission should become an executive agency of the Department of Justice, and that the Chief Executive should be a statutory appointment responsible for decisions on civil legal aid applications without any involvement on the part of the Minister or staff in the core of the Department. Following a public consultation on the report, I announced my response to the House on the 2nd of July 2012. Along with my response, I published a departmental action plan setting out 38 projects to take forward the recommendations of the review, one of which was tasked with examining the future structure for the delivery of legal aid. This included a detailed analysis of the consequences of delivering the administration of civil legal aid through an agency, taking cognizance of the 3 strategic objectives I had set out in the departmental action plan: improving access to justice, bringing legal aid within budget, and improving governance and accountability. A number of options were considered as part of the analysis. Based on a quantitative and qualitative analysis, the findings endorsed the recommendations in the Access to Justice Review that the delivery body for legal aid should be an agency. Before accepting these findings, I wanted to be sure that appropriate safeguards could be put in place to protect the independence of decision-making in the granting of civil legal aid. As a result, safeguards were developed, and I carried out a public consultation on the appropriateness of the safeguards. As a result of responses to the consultation, I took steps to further strengthen the safeguards, and these are reflected in the approach I have now adopted. I am satisfied that the proposed new arrangements will be protected from external influence and, in particular, be free from political or sectional interest. Individual decisions will be taken on the merits of the case and not influenced by political or budgetary considerations. While I will legislate and issue guidance on legal aid matters, I will not play any part in decision-making on individual cases. The main purpose of this bill is to dissolve the Northern Ireland Legal Services Commission and transfer its functions and staff to an executive agency, which is to be established within the Department of Justice. It will also set in statute safeguards to protect the independence of the individual decisions on the grant of civil legal aid. There are several key safeguards. The first is the designation of a civil servant as the Director of Legal Aid Casework, who will be responsible for individual decisions in the award of public funding in civil cases. In taking these decisions, the Director will act independently of the Department and the Minister. The Department and the Minister may issue guidance and directions on how the Director carries out his functions, and any guidance and directions must be published. However, the bill expressly provides that the Department and Minister are prohibited from issuing guidance or direction in respect of individual decisions. The bill imposes a duty on the Department to ensure that the Director acts independently of the Department when applying any general guidance or direction to an individual case. Secondly, the bill contains a regulation-making power to enable the appointment of an independent appeals panel to hear appeals against the decisions taken by the Director. This will help to ensure that there is an opportunity to challenge the decisions of the Director to refuse to award funding or indeed further funding in an individual case. The regulations must require an appeal panel to provide written reasons for its decisions on appeal. I will be supporting this with robust administrative procedures to ensure that a reasoned explanation is given for the refusal to award funding. The bill also makes provision for the transfer of staff from the Commission to employment in the Northern Ireland Civil Service, and in doing so protects their terms and conditions of service. Mr Deputy Speaker, I can advise that we have just received DFP approval to align the Commission's pay scales to the Northern Ireland Civil Service pay scales in advance of the move to agency status. This increase will be backdated to devolution, and it is our intention to pay the increase together with the back pay, subject to negotiations with the trade union, in April salaries. The main statutory provisions governing legal aid are the Legal Aid, Advice and Assistance Northern Ireland Order 1981 and the Access to Justice Northern Ireland Order 2003. The 2003 order will ultimately replace the 1981 order, but large parts of it remain uncommenced. This has been a complicating factor in bringing forward this bill, as it is necessary to make amendments to both orders to reflect the transfer of responsibilities away from the Commission to either the Department or to the Director of Legal Aid Casework. These are reflected in the lengthy schedules to the bill. The bill therefore makes changes to both orders to reflect the transfer of responsibilities and also to support my wider legal aid reform programme. Let me make very clear that the amendments to the existing legislation do not have any impact on access to justice or in any way restrict eligibility for legal aid. In order to support my legal aid reform programme, the provisions in Articles 10 to 14 and 17 to 20 of the 2003 order regarding civil legal services will be commenced on the same date that the Commission is dissolved and the agency is created. Articles 15 and 16 relate to the funding code, which I do not propose to proceed with. The funding code was originally intended to set out the criteria for determining whether civil legal services should be provided in a specific case and what service is appropriate. Following extensive work and research and taking on board experience elsewhere, we have concluded that the funding code is an unnecessarily elaborate approach which would not best serve the needs of individual legal aid clients. Consequently, the existing arrangements for merits tests will remain. The benefit of commencing civil legal services under the 2003 order is that this will provide greater flexibility regarding the people eligible to receive public funding in civil cases and how that funding is delivered than is currently provided in the 1981 order. For example, it would allow regulations to prescribe that certain proceedings may be funded without reference to an individual's financial resources. Regulations could also delegate decision-making on financial eligibility to a solicitor or other provider. It allows for non-court-based solutions, such as mediation or telephone advice, and to enable better use of the private or voluntary sector to provide services, for example, through law centres or advice services. All of these provisions were already on the statute book in the 2003 order, but have not yet been brought into force. In order for civil legal services to be commenced, a suite of subordinate legislation will be required. This subordinate legislation will be subject to further scrutiny by the Assembly. Some of the legislation will involve the Assembly's affirmative resolution procedure. This is an important point. All further reforms to the legal aid system will be brought before this House before they can come into force. Pending the commencement of the provisions in Articles 21 to 31 of the 2003 order regarding criminal defence services, representation in criminal cases will continue to be provided under Part 3 of the 1981 order. Accordingly, as an interim measure, the bill will also amend Part 3 of the 1981 order to replicate some provisions of the 2003 order regarding the assignment of solicitors and counsel, provide for a registration scheme, and place restrictions on the disclosure of information in relation to criminal legal aid applications. The Coroners Courts part of the bill will make the Lord Chief Justice the President of the Coroners Courts and require him to appoint a presiding coroner. This will formalise the Lord Chief Justice's responsibilities in relation to the Coroners Courts in line with the existing arrangements for the other court tiers in Northern Ireland and is intended to assist in the better administration and case management of inquests and the Coroners Courts generally. These changes flow from a recommendation in the review of the criminal justice system in Northern Ireland made in the year 2000 that the Lord Chief Justice should have a clearly defined position as head of the judiciary. The review also considered that a President or Chief Judge at each tier of the courts might be beneficial. Those recommendations were initially implemented in the Justice Northern Ireland Act 2002, which made the Lord Chief Justice the President of all the courts except the Coroners Courts. It isn't clear why they were excluded at that time. This may have been an oversight, or it may have been considered appropriate to await the outcome of other reviews concerned with the inquest process which were ongoing. In any event, the Lord Chief Justice raised this with me in December 2012, and this bill provides the first opportunity to take these amendments forward since then. To sum up, the purpose of the bill is to improve the administration of the legal aid system in Northern Ireland and to introduce more effective case management in the Coroners Courts. These reforms are, I am satisfied, both timely and necessary. Mr Deputy Speaker, I commend the Legal Aid and Coroners Courts Bill to the House.
Call Mr Paul Givan, Chairperson of the Justice Committee.
Thank you, Mr Deputy Speaker, and can I apologise for missing the initial opening remarks of the Minister, but thank him for outlining the general principles of the Legal Aid and Coroners Courts Bill, and I'm pleased to be able to speak in the debate today on behalf of the Committee for Justice. This bill is a key part of the wider programme to reform the legal aid system in Northern Ireland, and as such is supported by the Committee for Justice. The Committee has spent a considerable amount of time scrutinising specific proposals for reform of both criminal and civil legal aid, largely through subordinate legislation over the past number of years. As members will be aware, there have been ongoing issues in relation to inaccurate financial modelling and forecasting, lack of accountability and significant budget overspends. It is imperative that these issues are addressed. The change of status of the Legal Services Commission from a non-departmental public body to an executive agency of the Department of Justice provides the opportunity to improve the governance arrangements, and the Committee will expect to see increased transparency, accountability and efficiency. The Committee first considered the proposals for a public consultation on these changes in February 2013, noting the proposals resulted from a recommendation in the Access to Justice Review, which had attracted general support. The Committee agreed that the consultation should take place, and it would consider the issue further when the results of that consultation were available. Departmental officials subsequently briefed the Committee on the results of that consultation in June 2013, and a range of issues were discussed. These included the need for assurance that there would be independence in decision-making on granting of civil legal aid, the likely savings that would result in the change of status of the Northern Ireland Legal Services Commission, the position regarding the Northern Ireland Legal Services Commission's accounts, which members will know have been qualified by the Northern Ireland Audit Office for a considerable number of years, and what effect this would have following the change in status, and the mechanism to deal with appeals where legal aid is refused. Following the briefing, the Committee agreed that it was content for the Minister to bring forward a bill to make the necessary legislative changes. More recently, the Committee received a briefing from departmental officials on the principles of the bill, during which they highlighted that it now includes the provision, as the Minister has outlined, to make the Lord Chief Justice the President of the Coroners Courts and require him to appoint a presiding coroner, thus formalising his responsibilities in relation to the Coroners and Coroners Court. Given this provision arises from a recommendation in the review of the criminal justice system in Northern Ireland, completed in 2000, the Committee questioned the delay in bringing forward this change and has requested further information on the reasons for this from the Department. And maybe the Minister can go a little bit further where he's indicated he thinks it maybe was just an oversight. Maybe that is all the information that we know of, but it would be useful if we can know a little bit more about that delay. The Committee noted the key safeguards in the bill to protect the independence of individual decisions on the granting of civil legal aid, which include the Director of Legal Aid Casework being responsible for individual decisions independently of the Department, and the establishment of an independent appeals panel. Officials also confirmed that the amendments to the Legal Aid Advice and Assistance NI Order 1981 and the Access to Justice NI Order 2003 do not have any impact whatsoever on the parameters of those who are eligible for legal aid. Following the briefing, the Committee agreed on the 13th of March this year that it was content to support the principles of the bill at second stage. The Minister of Justice has discussed with the Deputy Chairman and myself on a number of occasions on the possibility of the Committee keeping the committee stage of the bill as short as possible to enable the bill to receive royal assent in the autumn, allowing the agency to be formed shortly thereafter. Given that the bill is largely technical in nature, there were few substantial issues raised during the Department's consultation, and supporting subordinate legislation will also be required, some of which will involve the affirmative resolution procedure, which will provide further scrutiny opportunities. The Committee has agreed in principle to a 10-week committee stage. We will, however, wish to give further consideration to the feasibility of this once we have analysed the written evidence received on the bill. So, Mr Deputy Speaker, if we can make this process go through as quickly as possible, while still doing our job as we are mandated to do, then the committee is up for trying to facilitate the department in getting this bill through the relative stages. At times, less can be more, and committees, I think, in this House sometimes do unnecessarily lengthen their scrutiny stages. And if we can do this, giving proper justice to the work that we have to do, then I think that's appropriate that the committee would try and work to that. And if we can do it, well then I think that's for the betterment of the piece of legislation and what it's trying to achieve. The Attorney-General for Northern Ireland has also asked the committee to consider a potential amendment to the bill. The Attorney-General has the power under Section 14(1) of the Coroners Act, Northern Ireland 1959, to direct an inquest where he considers it advisable to do so, but has no powers to obtain papers or information that may be relevant to the exercise of that power. He has experienced some difficulty in recent years in securing access to documents that he has needed, and the proposed amendment to the 1959 Act would confer a power on the Attorney-General to obtain papers and provide a clear statutory basis for disclosure. He's indicated that the principal focus of his concern is deaths that occur in hospital or where there is otherwise a suggestion that medical error may have occurred. So the committee will consider the Attorney-General's proposed amendment during the committee stage and intends to seek the views of relevant stakeholders to inform its consideration of it. An oral evidence event planned for May will also provide an opportunity for members to explore any other issues relating to the bill, and as Chairman of the Committee for Justice, I'll be supporting the principles of the bill and looking forward to getting into the scrutiny stage of it. Just briefly, Mr Deputy Speaker, speaking as an individual MLA, obviously the Attorney-General's request will need some scrutiny. If it is, as suggested, related purely to deaths that occur because of some medical issues, then I'll want to see exactly how the amendment will ensure that that is indeed the area that it is covering, because other members may be of a view that it should be a much wider scope. So I think members will have an interest into that particular issue, but certainly I would want to try and assist, given some of the events and tragic deaths that do occur within our health service. I think these inquests can be helpful, and disclosure is obviously important. So I would want to give it proper consideration in dealing with it. Obviously, the issue of legal aid has been one that this House has considered now for a number of years. The accounts have been qualified, and indeed one of the reasons for them being qualified have been that the potential for fraud could not be ruled out. And that is an issue that I know has concerned all of the members in this House, that may well have happened, particularly given that we're talking about the legal profession and obviously the concerns that arise from that. So we need to get to a system where the clear framework is in place for the administration of legal aid. The days of people being able to put in bills without ever backing up the work that they claim for should be over, and there needs to be transparency and accountability, Mr Deputy Speaker, when it comes to taxpayers' money being spent, and the legal profession aren't immune from that, and change is on the way, and I think change will come to how civil legal aid is structured. Now, I'm quite happy to, obviously, as we do, get into the debate of what an appropriate level of remuneration should be, and ensuring that the citizens of this state have access to justice, and they are obviously important considerations that need to be given. But certainly the days of old can't be allowed to continue and will need to change, and I think bringing the agency into the department should assist in that. And then the criticisms that have been made hopefully can be somewhat ameliorated, because the Commission have often forecasted spend on legal aid and that hasn't been accurate. Nevertheless, I have some sympathy, given the system that they're having to operate under, where you aren't able to accurately forecast the level of expenditure on legal aid, and there's some elements of it outside their control. as well whenever additional judges are appointed, and the process of dealing with cases has accelerated, and obviously that can have an impact as well. But there has been some criticism in the past from the legal profession. Some of that I think is justified, and these changes hopefully will try and address those. We'll want to explore the Lord Chief Justice's request. I appreciate it was in this report back in 2000, but one does have to ask the question, is it really just about the personnel to do with how efficient or not the Coroner's Court operates? Because there doesn't seem to be any great structural change through this, rather a change of personnel as to who ultimately has authority over the Coroner's Court. So I want to try and tease out what actually is going to be different structurally to try and deal with some of the issues that arise within the Coroner's Court. And obviously the Lord Chief Justice is a very powerful individual, not only because of him being President of the Court and now this further request to deal with the Coroner's Court. He's also Chairman of the Northern Ireland Judicial Appointments Commission, and that of course has attracted considerable debate of late in terms of how, to use the phrase that the Attorney General coined, of judges appointing judges. And I think there is some concern that we do need to look at how being President of all and the Chairman of the body that appoints, is there any conflict from that? And obviously that's another piece of work that the committee is looking at. So I look forward, Mr Deputy Speaker, to getting into the detailed scrutiny work that the Justice Committee has always proven itself to be very adept at getting into, and I look forward, as usual, to working with the Minister and his officials, who have always been very obliging to the committee. Thank you, Mr Deputy Speaker.
Call Mr Raymond McCartney.
I'll ask Con Cooler. Thank you very much, Deputy Speaker. And again, can I apologise to the Minister for being also late, like the Chair. I was just running late and doing something. But as outlined by the Chair, we as a party were supportive of the principles of the bill at committee stage, and indeed the process which the Minister laid out in terms of the intended changes and consequences we would be broadly in support of. And the process of scrutinising it as laid out by the Chair, we look forward to trying to assist the Minister in doing this as quickly as possible, but certainly in an efficient way, ensuring that proper scrutiny is carried out as outlined by the Chair. For us, I think the idea and the concept of the Legal Services Commission becoming the agency as outlined is a good thing. Particularly in both the Minister and the officials at the committee, and indeed the explanatory memorandum outlines that it's about trying to increase transparency, accountability and efficiency. And I think when you're trying to do and achieve that, then we certainly want to assist that, because I think, and the Chair alluded to it, and it's been something which has featured at a number of occasions by the committee to officials, is the idea of the financial modelling, sometimes the inability to forecast the budget, and the Chair alluded to some of the problems that existed. Hopefully this will help regularise that, and forecasting will become better within the limited circumstances. I think similar to the idea of the Chief Executive becoming a statutory office holder is a good thing. It removes any, and that's not to say there was any responsibility in the past, either on departmental officials or the Minister, that in some way they could interfere or have any sort of say over and above what they're entitled in terms of legal aid. So I think that's also to be welcomed. We also welcome the safeguards outlined within the bill. And again, the Minister, when he was speaking, alluded to that. This is not about changing aspects of legal aid in terms of access or provision, or the core ethos of legal aid, which is to provide assistance to people seeking justice who haven't got the means, and that it is well protected. I think the second aspect of the bill is the idea of the Lord Chief Justice becoming the President of the Coroner Courts, and from our understanding that's why we would be broadly in support of that, although the Chair has obviously brought things to the table which will be scrutinised, and rightly so. But for us, it's about efficiency, and if that's the rationale, that there's better case management, better use of resources, and we have seen that in terms of faster, fair justice, where there's better case management, then there's better output, and that means that people's, in terms of interest of justice, is served and served well. We would broadly support the amendment as put forward by the Attorney General. Again, I mean, the Chair has indicated that there will be a degree of scrutiny required. There may be people who want to broaden the scope of what papers he's entitled, but I think where the Attorney General has found a particular gap for his work, then I think it's worth examining, and certainly we'll come at it with that in mind. So we look forward to the scrutinising this through the committee. We know it's an ambitious timeline, but we certainly, from our party's perspective, we will want to give this as much attention and the required attention, and certainly assist the Minister to try and bring it through the procedures as quickly as possible. So we broadly support the principles of the bill.
Call Mr. Alban McGuinness.
Thank you, Mr. Deputy Speaker, and on behalf of the SDLP, can I welcome this bill and give this bill our general support. We will have some concerns about various aspects of the bill, but in general terms, we are supportive of it. Could I say that the Legal Services Commission has had a fairly sad history in terms of its efficiency and in terms of its ability to forecast and really to deliver as a public body, and it has, I think, reached the end of its tenure. The Criminal Justice Inspectorate, in its report in November of last year, concluded, and I quote from Mr. McGuigan, the Chief Inspector of Criminal Justice in Northern Ireland, however, and this is dealing with the Commission, however, our overall conclusion is that legal aid arrangements in Northern Ireland are not fit for purpose or in need of radical reform. And as the body tasked with looking after legal aid and legal aid disbursements, the Commission sadly has not reached the standard that we in this Assembly or the public at large would have wanted. I don't blame the Commission in itself. I think it probably was not properly resourced. I think it had a difficult task. Legal aid is a demand-driven area, and it is something which is difficult to actually keep track of and to control. But, Mr. Deputy Speaker, I do not think that the Commission was given the wherewithal in order to deal effectively and efficiently with legal aid. And perhaps if I could go back to the report that I mentioned to you, the report says this, that part of the problem has been the shortcomings in the effectiveness and efficiency of the Commission. There has been a succession of reports in recent years critical of its management, and the Department of Justice now plans to legislate to change it to an executive agency. And then goes on to say that the Inspectorate supports that move. It does further add that systems are overcomplicated and are managed inefficiently with little use of modern technology. Half of all applications from solicitors had to be returned to them because the forms were not completed properly. And there are frequent challenges to the decisions made about funding because the criteria is not clearly set out. Staff morale is poor and performance management has not been properly implemented. The IT systems do not allow targets to be set and monitored in a meaningful way. The business of the Commission needs to be properly analysed and modelled so that new structures and performance targets can be put in place, supported by state-of-the-art technology. If this were done, there could be significant savings in administration costs, and adds in brackets, with corresponding benefits to the legal profession, and improvements in the timeliness of decisions and payments. And if I could just say that whenever I was a practising barrister, the timeliness of payments was one of the most difficult things that one had to deal with, because you just simply didn't know when the Commission was going to pay, or if ever it paid. I remember even receiving payments years after the case had been completed. In fact, at a time when one had forgotten that you'd actually done the case. But that is a personal reminiscence of my own encounter with the Commission. But I do want to make one important point, and that is this: the Commission will now be transformed into an agency, and I welcome that. I think it's important, because clearly this body was not equipped to deal with the work that was given. However, I do say this to the Minister, Mr. Deputy Speaker. The Minister must assure this House that the agency will be given wherewithal in order to efficiently and effectively deal with legal aid. If it's not given the technology, if it's not given the resources that are required to deliver an efficient service, then what we're doing here today is a waste of time. So I would seek that assurance from the Minister. The other assurance that I would seek from the Minister is this: that in relation to the costs of the Commission, and the costs of the Commission are very high, they're approximately 8 million a year, and the Minister can perhaps give us a more accurate figure than that, but in or about 8 million a year. That, to my mind, is a very high demand on the public purse. And we do talk, and properly, about the difficulties with legal aid and the fact that the budget overruns and so forth. But we must ensure that the body that is administering legal aid does so in an efficient manner in terms of cost. And I would seek that reassurance from the Minister. Further point I would make in relation to the staff, and in the Criminal Justice Inspectorate report, it refers to the staff as being demoralised. And I know from personal knowledge that the staff were demoralised. Now, I think that the effect of this change might be to give them a greater sense of purpose. It may actually improve their morale. It certainly will improve their pay, which has been a vexed subject over a prolonged period of time. And I welcome what the Minister has said in relation to members of staff being paid in accordance with Northern Ireland civil service rates, and that is to be welcomed. And I think the staff quite naturally will welcome that, but I think it may also improve the service that is being delivered by those staff who will be transferred. Could I make one general point, and that is this: in relation to legal aid, it is accepted by all in this House, not least myself, that there must be, that legal aid has to be brought into budget. It is important that that happens. But I do stress this point, Mr. Deputy Speaker, that in so doing, and the Minister has made strides in relation to that, but in so doing, I think it is important that access to justice is not in any way impeded. You can make all the cuts that you want to a service, but at the end of the day, if you make such excessive cuts, you're actually diminishing the service that you're delivering to the public. And that is a very, very important point to stress. Seems an obvious point, but I'm not certain that the department fully appreciates that point. I think the department has made cuts which have been very significant. The department will make further cuts that I believe will be significant again. And I think we're on the edge of making cuts which could, in fact, create a crisis within the delivery of the service that we're talking about. Now, I know that this bill does not directly affect that, but nonetheless, I think it's important for members of this House to take that into consideration. So I make those points to you, Mr. Deputy Speaker, and I hope that those points will be taken on board by the Minister. The Minister, in answer to questions yesterday in the House, indicated that in fact already savings of 20 million have been made in criminal legal aid, and that in addition to that he was hoping to make annual savings of around about 18 million, and that with further changes to Crown Court fees for criminal work, he estimated that there would be other savings to the tune of 5.5 million. That's 23.5 million, in addition to the 20 million that has been made already. That is a very substantial saving indeed. And I'm in favour of savings like that if at the same time we can preserve the sort of service that I believe the public are entitled to. But if those savings go beyond the point where a service cannot be delivered, then I think that that is a backward step. Can I further say to the Minister that I take on board what the Minister has said in relation to the appointment of a Director of Legal Aid casework, and that he should or she would exercise their office separately and distinctly from the department. That is a very, very important distinction to make in terms of individual cases. And that in addition to that, the Minister preserves the merits test in relation to the grant of legal aid, and that the Minister has in fact taken that step and will preserve the merits test as an important safeguard in relation to the grant of legal aid. But could I say to the Minister that officials, whenever they came to the Justice Committee, indicated that in relation to appeals, there would be panels of at least 3 people dealing with appeals, dealing with rejections. Now, that is, I think, an appropriate step and safeguard. It was further indicated that at least one of the panel would be a lawyer, and that possibly that person would take a presiding role within the panel. I don't see that in this bill. It may well be that the Minister intends to put that into regulations, but it does not appear to me on the face of the bill. Perhaps I'm wrong on that, but I would emphasise the importance of making sure that there are legal representatives involved in the appeals. And I say this not because I think that they will be self-serving, but because they're in a position to make the determination in relation to merits. These are practitioners. I believe that they will do so in a bona fide manner, and will do so independently. I do not believe that simply because you've got lawyers there on appeals, they will simply say, well, we'll do a good turn to this solicitor or that solicitor. I think it's important that professionals who know what cases are about, who know the nature of these appeals, should be there to determine the appeals on the merits. And I believe that they will give good service. And in fact, Mr. Deputy Speaker, I know that the current panel that deal with civil legal aid do so in an independent spirit of mind and do so on the merits. And I have no fears that would in fact be prejudiced in any way. I would prefer if the panels were completely made up of lawyers. I think it's important that lawyers have a leading role. Certainly, the presiding chair in the panel should be a lawyer of that should be at very least a minimum. But as I say, I don't see that on the face of the bill, and I could be wrong about that, and if I am wrong, perhaps the Minister will direct me. One further point that I would like to make is, and I preface this by saying the following, that in any democratic society, I think it is very important that there be a distinction, a separation of power between the judiciary and the executive and the legislature. That is very, very important. And I think that's taken for granted by everyone in a democratic society. But of considerable importance in any democracy is the independence of the legal profession. I think the legal profession should be free and independent because they provide a real safeguard to the power of the state. I think it's very important that be preserved. But what I do see in this bill, and I hope I'm wrong about this, is an attempt to impose what I think are inappropriate regulations upon the legal profession. And I think if you look at the bill, you can see that in relation to regulation which the bill would hope to impose upon the legal profession. I think if we look at, I think it's 36B, Register of Solicitors and Counsel eligible to be assigned, and that under 36BA, make provision for the registration by the Department of Counsel and Solicitors who are eligible to be assigned in pursuance of criminal aid certificates. And it goes on. I'm not going to go into the detail of that. But I really do think that the registration of counsel and solicitors is an unnecessary step. And I think it's unnecessary and an elaborate approach to the assignment of professionals to legal aid. And I do make this point very seriously, that the department should look at that. I'm not certain that that is the right direction which to go. And I go back to my original point that there should be an independent legal profession in any democratic society. And I think once you start to register solicitors and barristers, then you start to erode that level of independence of the legal profession. And I say that to this House, and I warn the House about this. I do not believe that that's the right road to go down. So I make those points to the House in relation to the Lord Chief Justice and the Coroners Court. I hear what the Chair of the committee has said. I think that this is probably more of a formality than anything else. I don't think that it means an awful lot in terms of change and the operation of the Coroners Court. Lord Chief Justice has an important role, an important judicial role, but he also has an important administrative role within the judicial system. And he should, if he requires a legislative basis for doing that, I think that he's entitled to receive that. I would Mr. Deputy Speaker, I will conclude there and simply reiterate the point that I've made at the very beginning, which is that we welcome this bill, but there are points of concern which need to be addressed, and I hope during the course of this legislation that we will be able to address them in a forthright manner and a manner which will get the right result. Thank you.
Call Mr. Tom Elliott.
Thank you very much, Deputy Speaker, for this and for the opportunity to speak on this. I note there is almost a level of agreement breaking out between parties here, and I'm sure the Minister will be pleased to hear that. Just a comment on Mr McGuinness, who had indicated and give us a story when he was involved in the legal profession himself and about how slow some of the payments were coming through. I'm sure he'll have some sympathy now and even empathy maybe with some of the farmers in our community who have to wait quite a long time for single farm payments. So maybe our friend from North Belfast can realise now the difficulties. But to be fair, Deputy Speaker, I think there is broad agreement in the committee, and I take the committee chair's point about trying to progress the bill with a reasonable amount of speed, and certainly trying to carry out, while proper scrutiny, to do it in as short a time scale as possible. However, it does raise the question, Deputy Speaker, that this has come from a review that was carried out in the year 2000, 14 years ago, and it has been on the books, I think, in our briefing since the year 2004, 10 years ago. So I'm just wondering why the delay until now. I know at the committee I did ask, and there was an intention to come back with some information. Maybe the Minister can give us a degree of information today as to why it has taken so long to come forward. As many others have indicated, this is to replace the Legal Services Commission, and that is a body that has not been endeared itself with positivity to the wider public, or indeed to members of this Assembly in recent years, as to particularly around the management of it, or how we see the management of it. It may be much different if you're from the inside looking out, but I know from our perspective, or from my perspective, the management processes appears to have been quite difficult. I also note that the bill indicates, or the briefing indicates, that this legislation will build in safeguards and independence. And I do have a number of queries for the Minister at this particular stage of the legislation, and that is the people that are likely to be employed within the new agency are seemingly going to be transferred just from the Legal Services Commission. So I think the Minister does need to explain if it's just a rearranging of the deck chairs, or if there is a genuine change here from the Legal Services Commission to being an agency. We need to be confident of that, and certainly the wider public, I think, need that confidence as well, and they need to hear that. I note there was an indication around the staff that would change, and that their terms and conditions may change. So maybe the Minister could elaborate to some degree on that aspect as well. I note Mr McGuinness had highlighted that the Legal Services Commission cost $8 million to manage and operate. I think from the briefing we got at committee it said $7 million, and again I'm just wondering from the perspective of the wider public if there can be significant efficiencies from the new agency, and what those efficiencies will be. If it's going to be significant, I would like to hear how that is going to be put in place, or if it's just some sort of token, then there will be questions arising as to the real reasons for the change. I do note as well the Attorney-General has asked for an amendment to be put in place, and I think that needs some scrutiny, whereby the Attorney-General has indicated that he needs more powers to obtain papers and information. And by and large, I don't think we would object to the principle of that, but the reasoning behind it, and indeed the management of it, I do think needs a level of scrutiny, and certainly we would like to hear more about that before we can approve it. So again, I think, Deputy Speaker, without delaying the process, broadly in favour in principle, but I do note that there is some scrutiny to be carried out in the committee, and indeed when we come back here for further stages. Thank you.
Call Mr. Kieran McCarthy.
Last come call you. Thanks very much indeed, Mr. Deputy Speaker. And it is, as the former Speaker, Mr. Eilert, remarked, it's good to see general support all around the House this afternoon for the bill. The Minister must be very pleased with what he's hearing. I, like others, Mr. Deputy Speaker, support the bill at its second reading this afternoon. I do so on behalf of the Alliance Party and in place of my colleague Mr. Stuart Dixon, who actually serves on the Justice Committee, but who unfortunately has taken ill and therefore cannot be present today. My brief remarks reflect Mr. Dixon's views and the views of the Alliance Party, which are, of course, naturally supportive of the Minister's bill and of his ambitious programme of reforms across the justice system. We couldn't do otherwise, could we? But this piece of legislation, no, we couldn't. This piece of legislation, Mr. Deputy Speaker, represents another step in those much-needed reforms. And thank God for a local Justice Minister who is prepared to make progress on these much-needed reforms at this time. As the Minister has said, one of the recommendations arising from the review into access to justice was that the NILSC become an executive agency of the Department of Justice, and that safeguards to be put in place, such as making the Chief Executive a statutory appointment, responsible for decisions on civil legal aid applications without any involvement on the part of the Minister, any political institution or staff in the core of the DOJ. Mr. Deputy Speaker, the bill provides a number of welcome safeguards to protect the independence of decision-making in the granting of legal aid. Decisions on individual cases will be taken by a statutory office holder, the Director of Legal Aid Casework. There will be a requirement to publish general guidance and direction on legal aid policy provided by ministers. Ministers will be specifically prevented from issuing guidance or directions about the discharge of the statutory office holder's functions in relation to individual cases. And a robust and independent appeals mechanism will be established to consider appeals against individual decisions. Mr. Deputy Speaker, these measures represent a significant step forward, as under the current arrangements, reasons are not provided when an application for civil legal aid is refused. The Bar Council and the Law Society nominates the appeal panel members, and they also do not provide reasons for their decisions. I welcome the fact that the Department listened and acted on concerns raised during the public consultation and amended proposals relating to the appeals mechanism so that appeals will be heard by a panel of 3 with at least 1 practising lawyer. In conclusion, Mr. Deputy Speaker, the proposals set out in the bill will protect the independence of decision-making and should bring resource benefit also. I believe it is a positive step forward in our efforts to create a better justice system for everyone in Northern Ireland, and I fully support this important bill this afternoon. Thank you.
Call Mr. Jim Wells.
Mr. Deputy Speaker, first of all, could I fall on my sword and apologise for my non-attendance during DRD questions. It never ceases to amaze me how quickly ministers can get through questions. I didn't expect mine to be called, and I called that wrongly. Secondly, could I say that overall I support the proposal by the Minister, because something has seriously gone wrong with legal aid in Northern Ireland, and something very serious needs to be done about it. I welcome the fact that the Department will now have more control over the disbursement of legal aid in Northern Ireland. I think the closer we can bring this to government, the better, because we as an Assembly can scrutinise over what has been a very sorry mess. And unfortunately, I will recount some of the serious problems that have occurred both with the Law Society and the Legal Services Commission over this last few years. We're talking about a body here where its accounts have been qualified in every year since 2003. And that's a totally unacceptable situation, that accountants and auditors could not sign off on the accounts of a body spending over £100 million a year. That is unacceptable. Now, of course, much of this happened under direct rule, and I shudder to think what was actually happening during that period. One thing is certain, that under direct rule, vast quantities of taxpayers' money from London was poured into the back pockets of barristers and solicitors in Northern Ireland, to a degree that was totally unaccountable and totally unacceptable. Now, when we had devolved the devolution of policing and justice, we were able to open up the coffins, as it were, and look in and see what was going on inside, and it was a far from pretty situation. And I would have appreciated maybe if Mr McGuinness had indicated and declared his interest in this, because he at one stage was partaking of the services of both the Law Society and the Legal Services Commission. There may be others in this chamber this afternoon who may wish to declare a very substantial interest indeed in this issue. So the cats, as it were, amongst the barristers, they weren't fat, they were obese. There was huge amounts of money being poured in, and what we discovered was going on did not make pretty reading. First of all, we discovered that a very high proportion of cases in Northern Ireland were known as very high court cases, high cost cases. And when no one can work out who made the decision as to whether a case deserved or otherwise these designations, but obviously the barristers and the solicitors were extremely content with this situation. Now, once a case had been declared very high cost, it lived up to its billings. The costs were indeed very high, and some were quite shocking. Secondly, in many cases in Northern Ireland, there seemed to be junior and senior counsel appointed for an inordinately high number of cases. Now, I, for my sins, representing various constituents, have to sit in court often waiting to see when my case is going to be called. And I sit in and I watch some of those cases. And I really do wonder at times what the junior counsel does, apart from passing the occasional note through to the senior counsel. But obviously, that person is receiving a very significant payment for doing that. And it is interesting that in Northern Ireland, we seem to be drawn upon senior and junior counsel in far more cases than elsewhere than the United Kingdom. Then there's the inordinate long delays which occurred in cases. We had solicitors and barristers very quick to accept adjournments, because no doubt they were being paid while the case was adjourned, and then they could nip off and do other cases, again invoking the services of the Legal Services Commission and getting vast amounts of money. And then we had one of the most iniquitous practices which was discovered in Dungannon Courthouse of some solicitors who put in their fee bill based on the full case running its entire 15 or 20 days, when they had a very good idea all along that their client was going to plead, and plead very early. But of course they said, well, of course we deserve the full fee, because we had to prepare the case on the basis that this was going to go the full term. But when they had private discussions with their client, it was pretty obvious that he was going to plead. He did. The case maybe lasted a couple of hours, but the solicitors and the barristers still got their full legal aid entitlement. And that can be very significant. And I noticed that the judge in Dungannon put his pen one day and said, I am absolutely fed up with this going on with this particular firm of solicitors, that you knew this was going to happen all along. So when devolution occurred, we looked at the situation, and the budget situation. For instance, in 13-14, the budget was overspent by £40 million. But again, thanks to this Assembly, we were able to ask written questions of the Minister about the fees being paid to individual solicitors and barristers in Northern Ireland simply on legal aid. And some of the figures are quite shocking. For instance, in 1 year, there were, I'll have to quote them back quickly, there were 3 barristers in 2012 who earned over £500,000, including one lady who earned £800,000. I made this point. I was down in the court one day and I was accosted by a series of QCs, not a pretty sight I can assure you, who resented my comments. Indeed, it was almost unsafe for me to go into the court. who resented my comments. And one of them came up to me with great fervour and said, Mr Wales, you're wrong. You said I earned £800,000. Of course, that was only in 1 year. What happened in that year, as Mr Allister and Mr McGuinness will explain, is that fees that I had put in from previous years all stacked up in the 1 year. So I asked Mr Ford, what did the person earn in the previous 5 years? The average was £800,000. Now, I am told by barristers and QCs that the reason why we need to be paid £800,000, they need to be incentivised to produce the best possible case for their clients. Well, I would be incentivised on £300,000 a year. I don't need £800,000 to put my best case. Of course, I'm doing it for £48,000. Why is it? Why is it do we need to pay such extraordinary amounts of money to the QCs and the solicitors of this world to incentivise them? Can they not live on a measly £500,000 a year? Now remember, that is only what they're earning on their legal aid work. Of course, they have to supplement that meagre salary with the really lucrative work, which of course is the private practice. No wonder the QCs and the barristers and the solicitors did not want us to hear what was going on. 16 of those barristers were getting by on £250,000 a year on legal aid work, and the top 20 earned between them £8 million. And Kevin Winters in that year, one firm of solicitors was earning £2.5 million. And the Madden Finucane were not far behind them. And then we discovered, how were these fees assessed? And we have learned gentlemen here, men of the cloth, I don't think it's men of the cloth, but learned anyhow. We have them here today. Maybe they can correct me. But am I not right in thinking that the learned QCs, they decided the size of their fees? They did their court case, and they thought to themselves, well, I did a pretty good case for that gentleman, therefore I'm worth £34,000 for that case. Then they go next week and they say, oh, I wasn't too hot on that one, I'll simply charge £28,000 for that case. They put their bill into the Legal Services Commission, and the Legal Services Commission tugged their forelocks and said, thank you very much, and paid out. And what did the Legal Services Commission raise as a concern? Not the fees, but the travel expenses and the luncheon vouchers. You can't expect someone on immediately £500,000 a year to travel the whole way from Belfast to Dungannon and back and pay it out of their own pocket. No, they had to claim travel expenses and luncheon vouchers from the Legal Services Commission. Correct me if I'm wrong, gentlemen, but that's my reading of the report. Certainly.
I thank the member for giving way. Progress has been made in trying to deal with some of these aspects, and certainly the committee and the member will know we touched on how when the taxing master would take his decision, obviously those that have put in the claims, the QCs and barristers, would be allowed to appeal that decision. Once the Legal Services Commission got the power to challenge that appeal and request evidence to be produced, interestingly, quite a large number of those initial appeals were no longer pursued because evidence was being sought to justify the claim that was being made by the legal profession. The other change that this Assembly has made around the two-counsel issue and the requests for additional representation, that those judges who take that decision now need to provide an explanation. And once those judges were required to provide an explanation, rather than the immediate, Your Honour, this is a complicated case, I think I need additional legal assistance, and it was as quick as that, and the judge would say, granted. Now that there's a requirement to provide the rationale for that exceptional case to be made, dramatic reductions have taken place in the number of allocation of two counsel in those particular cases. So clearly some progress has been made, but I agree with the member, much more needs to be done.
Thank the Chair of the Committee for his helpful intervention, and I was just coming to what Mr Ford. I would disagree with the vast majority of what Mr Ford says, and I'm glad to say the Committee today disagreed with him on the Human Trafficking Bill because we have passed our recommendations on that, so we will be coming to a clash of two forces when that comes up. But what I would say to him, he was absolutely right to take on the Law Society in the early years of his ministership, but I hope he doesn't use this and quote it against me in the subsequent elections. He was absolutely right, but he wasn't brave enough. He faced down the Law Society and he said, I'm standing my ground, and he did invoke changes in criminal legal aid and had the full support of the committee, apart from Mr McGuinness, who perhaps was slightly worried about his future career. But secondly, he then turned his attention to civil legal aid, and absolutely right. He has cut down on that as well. But he needs to be braver. He needs to make the fundamental decision that legal cases in Northern Ireland should not cost more than the rest of the United Kingdom. If someone can get adequate representation in Buckingham or in Basingstoke for a certain fee, then that should be the fee that applies in Belfast. Because when you take out the serious cases, which are often terrorist-related, a bank robbery in Belfast is exactly the same as a bank robbery in Basingstoke and should be treated as such. And still, I believe we're still 20% more expensive in cases in Northern Ireland than the rest of the UK. And the question is, why? Why in Northern Ireland do we spend more per head in legal aid than almost any part of Europe? Why, having identified that the system is seriously flawed, why do we not take the courage in our hands and actually go at it root and branch and bring costs down to a reasonable level which remunerates the learned friends in this chamber and elsewhere, which means they maybe have to get by on £200,000 a year. My heart bleeds for them in the recession. But still ensures that people in Northern Ireland who have a genuine need of legal aid get good representation. And I believe, Minister, there's still an awful lot of fat left in the system. And I'm asking you, with the support of this Assembly, to take the courage of your convictions and to do more about it and to bring us down to the UK average. Because why this is serious, and I have, I suppose, to some extent been relatively light-hearted up to now, but why this is serious is the Public Accounts Committee and the Audit Office issued reports with serious reservations of what's going on. And year after year, the Department of Justice has to come back cap in hand in the monitoring round and ask for more money to make up the deficit in the legal aid budget. And 1 year recently it was £41 million. I think last year it was £19 million. Now, this may be small beer in the eyes of the Department of Justice, certainly small beer if I was a QC. But that's the equivalent of a new grammar school or a new secondary school every year. It's the equivalent of several hundred nurses. And we're taking that money and putting it into the pockets of people who are quite wealthy already. I read the Belfast Telegraph with great interest on a Friday night. You don't often see a QC or a barrister in Stubbs. You don't often see them going bankrupt. There is a lot of people at the senior level who are doing very well. Now, I have some sympathy, I have to say, for younger, recently qualified barristers and solicitors who are finding it difficult. Some of them can't get pupilages, and many of them are coming nowhere near the level of earnings that I've been quoting earlier. But the reality is there are many hundreds out there who are doing very, very well under the system, and they've had it good for many years, indeed many decades. And now it's time to draw a line under that and say, you've had your days in the sunshine, now here's the economic reality. Because remember, whilst the rest of society over this last 5 years has been suffering under recession, it seems to have bypassed the law courts completely. There doesn't seem to be any indication of people being made redundant at the high level. And still, even after Mr Ford's cuts, when we got the most recent indications of legal aid payments, still the top people were earning, indeed this year, one of them, Mr Berry, he earned £1 million in 1 year. Now that's an extraordinary amount of money from the taxpayer, £1 million, and then we'll supplement it, no doubt, with some real paying work in forms of private work. So, by all means, I support entirely what Mr Ford's doing, but it'll give this committee and give this Assembly to give him the backbone that he needs to stand up and to really crack this issue and to bring some form of sense to legal aid payments so we can then take the money and put it into our health service or into education, which is really necessary, rather than simply lining the pockets. Now, I've probably lost the friendship of Mr Allister for life from saying this, but I've no doubt he will stand up and make a very strong, supportive case, as he would as a QC. But I was very interested if he could debunk some of the comments I've made, or Mr McGuinness, or maybe any of the barristers on the opposite side, because I believe the public are with you, Minister, on this. I believe the public will back you. Even in Southampton, they will support you in what you're doing, and they will want to see barristers, lawyers and solicitors getting a fair return for their labours, but not one which is so excessive that's an embarrassment to you, to our committee and the Legal Services Commission. So I welcome the legislation. I hope it gives you the teeth to deal with a very important issue.
Call Mr Jim Allister.
Well, Mr Deputy Speaker, in aid of Mr Wells's blood pressure, I will declare that in my former professional life, I would from time to time have been the recipient of legal aid funding in respect of work that I did. I trust that satisfies Mr Wells. Could I just pick up, not to disappoint him, on a few of the issues that he raised. Now, I know Mr Wells has some experience of the courts, and I had the opportunity on one or two occasions to actually represent him. I don't recall if in any of those occasions he had the benefit of legal aid, maybe not. But no doubt he can tell us if he had. Yes?
Could I say on those occasions I got excellent representation from yourself. I paid for every penny of it out of my own pocket, and therefore it's not relevant to this particular debate because I would never have qualified for legal aid and indeed would never have applied.
And I'm sure he enjoyed the discounted rate that doubtless he got. Could I say, just to deal with a couple of those straw men that were set up, I would be very, very surprised if anyone in the category of the large earnings that he mentioned from the Criminal Legal Aid Fund was also involved in what he called private practice. It's all private practice, of course, but involved in doing commercial cases or civil cases or anything other than the criminal work. My experience would be that the top earning criminal practitioners, that's exactly what they were, criminal practitioners in the criminal courts who weren't supplementing income very much of at all from elsewhere. So I think that would be undoubtedly the case. It expresses some concern, as well one might, for newcomers to the legal profession, junior barristers, many of whom struggle hugely to find their feet, some of whom are of necessity recipients of welfare benefits because they cannot make ends meet. So this rosy picture that the bar and the legal profession is a gravy train unending is so wrong, particularly for many junior members of the bar, many of whom have to drop out of the profession because of the pecuniary pressures. Mr Wells expresses sympathy for them, but then in the same breath denounces the practice of having a junior barrister in a case along with a senior barrister. Well, how else do junior barristers progress through the profession but by that essential component, that being a essential component of the route? So I don't think you can seriously express concern for the hard times that many junior barristers experience and then at the same time denounce the practice of true counsel in the system. I think one is essential to resolving the problem of the other difficulties that some do. Could I say, Mr Deputy Speaker, that I very much welcome something the Minister said. It's not in the bill, but in the course of introducing the bill, he told us that finally there had been DFP approval for the financial settlement for the staff of the Legal Services Commission. Minister will know that's a matter I pressed upon him many times in questions for the last couple of years, and I'm pleased for those staff that before any new agency is established the matter has been resolved. I very much regret the feet dragging that there was for many years on that issue, and I think it reflected very poorly upon the Legal Services Commission in regard to how they handled that issue. But I am pleased that it has now been resolved and trust that that won't leave too much of a bad taste with those who were so badly treated in that regard as they move forward. I must say, few will lament probably the passing of the Legal Services Commission. They did not cover themselves in glory, and the delays and all of that were quite notorious. I heard well, I should say this first of all. Before we had the Legal Services Commission, we had legal aid administered by the Law Society. And they did it effectively on a shoestring, but they did it quite efficiently. And then we had the Commission, and the Commission, I think, for many, proved in many aspects a disappointment. Mr McGuinness referred to delays, and delays in the paying of fees could be quite notorious. I'm not going to suggest that this is at all typical, but in 2001 I received a fee, civil legal aid fee. I couldn't recall the case. When I checked back, I discovered I had done that case in 1979. 22 years later, I was paid. Now, I have to say, regrettably, I was paid at 1979 rates. I wasn't paid at 2001 rates, but I was glad to be paid nonetheless. Now, that is exceptional, but it was a common practice under criminal legal aid for there to be inordinate delays in the payment of fees. So much so that some of my former colleagues got quite excited at the publication of figures in 2004 and 2005, wrongly assuming that those were earnings of 2004 and 2005, not realising that, of course, those were earnings from many years before because of the time lag in payment. So lawyers under the Legal Services Commission also had their difficulties in terms of the delays in the payment system. And it really was, on many occasions, quite appalling. Yes?
I thank the member for giving way, Mr. Deputy Speaker. The member may be aware, but certainly I would like to put this to him and to other members of the House, that as far as family work is concerned, and of course that's under discussion at this moment in time because the department wants to cut representation and wants to cut fees and so forth in relation to family work, which is essential for this society. But in any event, many of the practitioners within the family bar were not paid for work over a period of 2 years. Not one penny did they receive for 2 years. Many of those practitioners were in fact young women who were unable to pursue their careers at the bar because of the lack of payment on a timely and appropriate basis. And could I also mention this point, Mr. Deputy Speaker, that whenever you're giving your tax return, you give your tax return on the basis of fees marked. In other words, if you mark fees for £10,000 or £20,000, whatever it might be for that year, you pay tax on that, whether you've received the money or not. And that adds to the burden of any sole practitioner at the bar.
Yes, I am aware of some of the particular issues that practitioners in the family division did suffer for a very protracted period. And I think they and criminal practitioners were particularly exercised about that, and with good cause. Now, of course, I think we all know that there's never going to be a public uprising in support of lawyers. It's just one of those class of individuals that people enjoy having a go at, and I think we saw some illustration of that today, but fair enough, we all have to be tough-skinned in these regards. I was going to come to some particular matters in the bill. I am concerned by some of the import of Clause 3 in the bill. The Minister tells us, there's going to be no ministerial interference, it's going to be a wholly independent arrangement. and that it will be very much arm's length, even though it's an agency within the department. But Clause 3 does tell us, in relation to the exercise of the functions by the director, that he or she must comply with directions given by the department about the carrying out of the director's functions. So it's a mandatory requirement. The director must comply with directions given by the department about the carrying out of his functions. And then secondly, must have regard to guidance given by the department about the carrying out of those functions. I can understand the necessity to put in the requirement to have regard to guidance by the department, but I do rather struggle, in the context of the arm's length transparency that the Minister suggested, with the notion that the director must be under a statutory obligation to comply with directions given by the department about the carrying out of his functions. That does seem to be rather overreaching and overbearing. And I suppose, not to hide behind the issue, part of my concern in that regard is that the department for which we can read the Minister, effectively, involves, in this instance, a Minister who has shown quite a vindictive aversion to the legal profession, I would have to say. I don't know what experience the Minister had in his former life as a social worker, whether he had some bad experiences at the hands of pugnacious counsel or not. But certainly I think the Minister does little to hide his contempt for the legal profession and for his, well, what's he done wrong? Well, there were one or two occasions when Mr. Wells was happy not to ask that question in respect of his own situation. So I am concerned that the Minister who wears that badge so proudly of his hostility to the legal profession and his total disdain and disinterest in the fact that many country solicitors' firms are being driven to the point of extinction by the cuts that he has imposed. I am concerned that the Minister with that pedigree is the person who in this legislation is given the statutory opportunity to compel the director to comply with directions he might give about how the director might exercise his functions. Now, I know it does go on to say that the department must not give a direction or guidance about the carrying out of those functions in relation to an individual case. Fair enough. But what about a class of cases? We do from time to time have classes of cases, like the cases there have been, for example, about deafness claims. There have been a number of those. If a number of cases can be classed together, is the Minister going to be able to give a direction, not about the individual cases that make up that class, but about that class of cases? Is that the sort of thing which we might anticipate? And it's because we have experienced and seen and heard the Minister's mind on these matters that I would have those particular concerns. Yes?
The member has raised a very suitable example. The recent deafness cases of the PSNI. I understand the figure was like £120 million, and over half of that was paid for legal representation. Is that not the very subject that the Minister should be involved in, to try and get those ridiculous fees down and get the money to the people who really matter, those who suffered the injury?
Yes, but the problem in the deafness cases wasn't the absence of direction, perhaps, in regard to legal aid. The problem in the deafness cases was the absence of direction in how they would be processed, which wouldn't be a power the Minister would have. How they would be processed in the court, how they would be listed, how there would be sample cases taken, etc. None of that would fall within these powers. That's where the problem lay in the deafness cases, as I understand it. Could I also say that I agree very much on the issue of the civil legal aid appeal panels, that it is imperative that there is significant legal representation on those. And let me dispel the myth that those civil legal aid panels are some sort of rollover opportunity for the profession. I remember very well, as a young barrister, spending many's a Friday afternoon, it often turned out to be, going before the legal aid appeal panel in the Law Society, comprised entirely of lawyers in those days. And the grilling one got in terms of seeking to make out where there was a merit in a case was quite considerable. It was no pushover. You really had to do your stuff if you were going to persuade that panel. And I never saw anything but a consciousness, as there should be, of the public purse. Two issues in applying for legal aid in a civil case. One is that the person reaches the financial threshold or falls within the financial ambit of those who should be supported. Doesn't need a lawyer to work that out. That's an administrative function, really, by applying various thresholds and guidelines. But the second issue is, even if you qualify financially, you still have to qualify by showing that your case is meritorious. Now, with all due respect to civil servants or lay people or whoever, I don't think you can properly do justice to an applicant for legal aid on the civil front, assessing whether or not their case has merit by putting it before people without the knowledge and the expertise and the experience to know if in law it has merit. So I think the adjudicators in that case have to be lawyers. And I think any diluting of that would be a backward step. And so I very much agree that that needs to continue within the arrangement. I also agree with Mr McGuinness in relation to Schedule 2 of this bill. I think that when it comes to this notion that you could have a register of certified or of eligible counsel, those who are registered and approved is the inference by the department under clause 36B that would be inserted into the legislation. The idea that only those registered by the department as eligible to be assigned in pursuance of criminal aid certificates, that's an idea which is quite preposterous. Very often, individuals, and it's a right they have, through their solicitor, exercise the right to say, I would like counsel A to do my case. Why shouldn't they ask for counsel A rather than be presented with a departmental approved list of those who are registered? And I very much resist the idea that the individual should be denied the right to choose his counsel, just as Mr Wells, on occasion, had that right to choose his counsel. So any individual should and must have that right. Yes?
I had the option of choosing the best counsel, and I got it, both at solicitor level and at QC level.
date those changes in pay and conditions to the point of devolution. In summing up, I also need to repeat the point which I made earlier on, but in particular reference to a point made by Raymond McCartney, that the changes to the legislation that we have proposed and which are before the House today are not impacting on the access to justice, are not in any way restricting the eligibility for legal aid. They're merely ensuring that we provide the service in a more efficient way. If I could deal with some of the specific points made by members. Mr Givan started off querying the issue of the delay in making the changes around the Coroners Service and giving the powers to the Lord Chief Justice and the institution of the presiding judge. Perhaps the kindest explanation I can give as to why there might have been delay is that at the time when this legislation was being proposed, there were a couple of inquiries underway in England and Wales, particularly arising out of the case of Dr Harold Shipman, which led to various work being done around the provision of coroner services. That may or may not have been the reason why progress was not made, but members of the committee in particular will be aware of the fact that I make it a point not to explain the actions of what went on before direct rule on the part of the Northern Ireland Office, and I'm happy to make that same point again this afternoon. The issue of cost was raised by a number of members. We had different figures of the current cost of running the agency. Both £7 million and £8 million was suggested. The answer, I believe, Deputy Speaker, is that both are correct. That the current expenditure on running the Commission is around £7.2 million per annum. On the basis of the improved terms and conditions for staff, it will rise to approximately £8 million per annum. Members raised in particular a contribution just made by Mr Allister, though was also raised by other members about the issue of the Attorney-General's concerns and in particular some other coroners' issues. My understanding is it may well be that such changes would not fall within the current scope of the bill, but of course that is an issue to be determined by Mr Speaker in the light of any amendments which may be put forward for consideration. It is not an issue for me to advise the House on the precise scope of the bill as it currently stands. References were made to the issue of transparency of the process and in particular to the appeals process. And I think it was Kieran McCarthy who most emphasised the issue of, for a change, reasons being given as to why decisions were taken on the granting or otherwise of legal aid, which I believe will help in ensuring greater efficiency. If people are aware of the reasons, they're perhaps less likely to appeal. But in response to both our barristers, both Mr McGuinness and Mr Allister, paragraph 622 of Schedule 2 sets out the broad outlines of the appeals mechanism to be determined by secondary legislation, and it is certainly the intention that I have at this stage that when those regulations are put before the House, and obviously committee members will have the opportunity to comment in detail, that it will institute a panel of 3 to hear appeals, which will be chaired by a legally qualified member. So that perhaps goes some way to addressing the concerns expressed by Mr McGuinness and Mr Allister. Both of them... Thank you, Wait.
I accept the Minister's assurance that this will be brought forward in terms of supporting legislation. But is there any reason why that could not be included on the face of the bill today or in the near future?
I could be pedantic, Deputy Speaker, and say, well, it couldn't be included on the face of the bill today, but Mr McGuinness corrected it to the near future. I think, frankly, that is an issue which I will leave with the members of the committee to consider as to whether they want that level of detail on the face of the bill or whether they're content to accept it on a secondary basis. And I have no doubt that will produce one of the more interesting debates within the committee's consideration. On the issue of what was described again by Mr Allister and Mr McGuinness, the issue of the regulation of the profession as was seen, I'm afraid I do disagree with the points they are making. If the government, the Department of Justice, whoever one wishes to term it, are paying for legal services on behalf of our constituents, the citizens of Northern Ireland, I believe it is entirely right that we should have the power to regulate those to whom those payments will be made as services are provided, because it is not an entirely private matter, as Mr Wells stated so eloquently on a number of occasions in terms of court cases he'd been involved in.
The National Health Service is a public service, you well know. if I want to go to a doctor, if I want to join a doctor's panel, I go along and I join the doctor's panel. If there's a space available, I get that space. I make that decision as an individual citizen. Why can the individual citizen, in terms of legal aid, not make the same decision or in a similar fashion?
Well, Mr. Speaker, Mr. Deputy Speaker, it's my understanding that if I wish to choose a GP, I choose a GP who is registered as such with, I think it's now called Business Services Organisation rather than directly with DHS SBS. I'll stand to be corrected on the precise details, but it is my understanding certainly that anyone who wishes to set up as a GP in terms of medical services has to be formally registered as providing those services within a particular area, and I think that's where the same issue would potentially apply. But again, that is an issue which doubtless the committee will wish to explore. I give way to Mr. Alistair.
But surely the parallel does exist. To be a practising barrister, you have to hold a practising certificate. To be a practising solicitor, you have to hold a practising certificate. So the registration already exists. And why does the Minister need more than what 36A 2 and 3 would give him? Namely, that a solicitor shall not be assigned in pursuance of criminal aid certificate if the solicitor for the time being is prohibited from being so assigned by an order of the solicitor's order or in respect of the barrister by reason of a determination by the Bar Council. So if there are miscreant solicitors or barristers who have been held to be inappropriate for the type of work they're wanting to do, the protection already exists under the solicitor's order and under the arrangements with the Bar Council. Why do you need then to superimpose your own system of registration?
To continue the medical analogy which Mr. Alistair started that comment, it is my understanding that a GP has to be specifically registered as a GP to carry out services in an area and not merely be registered as a doctor with the GMC. We may or may not need to stretch that analogy too far, but I believe it is a perfectly legitimate issue if the public purse is paying for a particular service that there should be an appropriate measure of regulation. And I'm not looking for what is reported as being intended in England or Wales of a small number of firms getting very large contracts for substantial regions of England or Wales. But I do think the issue of ensuring that those who are carrying out the services are guaranteed to be carrying them out in a proper way is an entirely legitimate aspiration. Sorry, go ahead.
Interested what the Minister has said. Is the Minister assuring the House that he does not intend to introduce contracts to firms of solicitors?
I think there's a significant difference, Deputy Speaker, between the idea of regulation and registration and setting up the kind of contracts which have been suggested for England and Wales, which appear to me to be detrimental to the issue of access to justice, as they have been reported to me.
Surely the other argument is that it's quite clear from all of what we've seen since 2003 there has been firms of solicitors and barristers who've been abusing the system. And surely by registration it means you've got the deterrent effect that if they do continue their practices and overclaim, they can be struck off, as it were. So therefore it's a deterrent and as an addition to ensuring quality of service.
Well, perhaps, Deputy Speaker, having given way to the member, I should now go into my usual position of defending lawyers against Jim Wells before Mr McGuinness and Mr Alistair feel obliged to do that on their own behalf, as has happened at times in the past, both in this chamber and in the committee. But again, that particular issue of how the profession is regulated will be an issue which I suspect the committee will wish to go into in some depth. Mr Wells spoke at some considerable length around the costs of the legal aid system, indeed the remuneration paid to lawyers. It was, as ever, a fascinating and interesting rant. I hope he takes the word rant as a compliment. I'm sure it was intended to be a rant. I do have to remind him again that on a previous occasion he talked about whether the lawyer on £800,000 a year could possibly survive on £600,000 a year, and I had to point out to him that also meant that the lawyer who was on £24,000 a year would have to manage on £18,000 a year. And there are clearly issues about remuneration for those in the early stages of legal careers. although the reality is that we do have significantly more lawyers per head of population in Northern Ireland than, for example, in Scotland, and that may be part of the issue. But, frankly, that was somewhat beyond the scope of the bill, as I understand it. But it does lead me to a point made in the final contribution by Mr Allister, in which he referred to my contempt for lawyers. I'm not sure where he gets the notion that I have contempt for lawyers. I have concerns about the public purse, and I have made no secret of my concerns about the public purse. I'm afraid I cannot agree, for example, with Mr Wells when he suggests that money which was taken off legal aid could be easily transferred to the health service or to education in the context where the DOJ budget is ring-fenced, because I can assure him there are many other aspects of the DOJ work which also require expenditure. I'll give way.
But correct me if I'm wrong, but if the DOJ at the end of, say, the June quarter found itself in surplus, does it have not the power to transfer that money back to the DFP for distribution to more worthy causes?
Mr Deputy Speaker, I could think of no more worthy cause than the DOJ. The reality is we are currently under the CSR period ring-fenced, but the point of allocating funds in the best way to meet the needs of this society are valid issues, whether we suggest they should go outside the justice family or not. But again, I repeat the point, I'm not sure on what basis Mr Allister accuses me of contempt for lawyers. I certainly can think of occasions when, during the first round of cuts to criminal legal aid, an email emerged which suggested that a fairly prominent solicitor had significant contempt for me in the dirty tricks that he was suggesting, but that appears to be somebody looking in a mirror and seeing something rather differently from the way it is. But in context of the point that Mr Allister made there, I believe it is appropriate that there should be a general power of direction from the Department and the Minister to the Director of Casework, because that is a general power and not a power relating to the management of any individual cases. And I do not believe that my actions as Minister in the almost 4 years I've had have suggested that I've shown contempt for lawyers or I would abuse such a power. Not, of course, that there is a suggestion that I am going to be the Minister of Justice in perpetuity, which appeared to be part of Mr Allister's fear that nobody else would ever get the opportunity to issue such a direction. But I give way to the Chair.
Mr. for giving way, and he touched on the first round of cuts. Maybe you can indicate how many millions were reduced through criminal legal aid, and I think at the time of those emails circulating, one senior legal practitioner talked about yellow pack justice being delivered if these cuts went through, threats of withdrawing from work, that this was going to have a devastating impact on the legal profession. I think it saved upwards of around £20 million, and I'm not aware of it having had a devastating impact on the legal profession, particularly those involved in criminal legal aid, where those initial cuts were directed towards. So if anyone is being held in contempt, it's those who seek to defend the indefensible system that has went on for too long, and for those who cried wolf around the original cuts that were put through by this Assembly, rightly so.
It's always a pleasure to agree with the Chair of my committee. The reality is £20 billion was taken from criminal legal aid, mostly by dealing with the issue of very high-cost cases, where there was an extraordinarily large proportion of cases certified as VHCCs in Northern Ireland compared to England and Wales. And I'm not aware that the justice system or criminal defence work has fallen apart in the 2 years since that became fully operational. I'll give way to a further member of my fan club.
Yeah, well, no, just on this issue, I can assure you, Minister, and many other issues we'll totally disagree. But could I say, having commented on Mr Givan's intervention, and I agree with him, will he now assure us that he's going to go the next step and bring legal costs in Northern Ireland directly into line with the rest of the United Kingdom, saving more money without affecting the quality of service?
Can I remind members we're dealing with a bill before us today?
In that case, Deputy Speaker, I will assure the member that I am seeking to ensure that the costs of legal aid are brought within budget in a way which continues to provide access to justice for the people of Northern Ireland, whether we're talking about criminal or civil matters. I trust I haven't intruded too far on your generosity in making that comment. I do think we've had a very useful discussion, Deputy Speaker. There have been a number of points raised which I suspect are going to provide an interesting time for the committee in the coming months. But with the sort of assurance that it looks like we might well get this stage of the bill passed, can I commend the bill for the approval of the House and wish the committee all the best as it carries forward its process in the coming weeks.
Members, the question is that the second stage of the Legal Aid and Coroners Court Bill be agreed. All those in favour say aye. Aye. Contrary, no. The ayes have it. The ayes have it.